Some cases never make the news. They don't have celebrity defendants or high-powered attorneys. They don't generate protest movements or late-night coverage. They move through the system quietly. A name on a docket, a file on a clerk's desk, a hearing scheduled between two larger, louder things. And sometimes, those are the cases that matter most. I want to tell you about a man named Walter Doss, 71 years old, a janitor, a man who had spent the better part of 5 decades cleaning other people's buildings and asking very little from the world in return. A man who, on a Thursday morning in March, sat down in a municipal courtroom facing a fine that would have taken everything he had. And I want to tell you about what happened when the judge actually read his file. Pay attention to how this unfolds, because the story doesn't start in the courtroom. It starts much earlier. And to understand why that Thursday morning mattered so much, you need to understand everything that came before it. Walter Doss had been a janitor at Meridian Office Complex for 23 years. Before that, he had worked a series of similar jobs: a school district, a hospital corridor, a downtown hotel that had since been converted into condominiums. He had never owned property, never held a salaried position with benefits that lasted more than a few years. He had raised 2 children largely on his own after his wife passed in 2004, worked whatever hours he could get, and somewhere in the middle of all of that, had managed to keep the lights on. He lived in a small rented house on Delwood Avenue, a street that had once been working class and proud of it, and was now caught in that uncomfortable in-between state that many urban neighborhoods occupy, part forgotten, part quietly being reclaimed by people with more money and different intentions. His neighbors had changed 4 times in 6 years. New faces, new cars, new expectations about what the street should look like. Walter was a tidy man. He was tidy by profession and by nature. His small yard was kept. His porch was clear. He did not leave things to accumulate. But in August of the previous year, his back had given out. Not dramatically, not all at once. The way backs give out in people who have been bending and lifting and scrubbing and mopping for decades. Slowly, then suddenly, then in a way that doesn't fully reverse. He had managed it with over-the-counter medication for a while, then with a prescription that cost more per month than he was comfortable admitting. He had reduced his hours at work. He had stopped doing the things that aggravated it. One of the things he had stopped doing was hauling the large refuse bins from the back of his property to the street on collection day. The bins were heavy. The path from his back storage area to the curbside required navigating 3 steps and a narrow gate. And his back, on the mornings when collection happened, simply would not allow it. He had asked his neighbor's teenage son twice. The boy had helped once, then moved on to other things in the way teenagers do. He had called the city's accessibility assistance line and been put on hold twice and disconnected once. He had meant to call again. He hadn't gotten around to it. For 11 weeks, his bins had not made it to the curb on collection day. The city's waste compliance program had been running an enforcement initiative that year. It was the kind of initiative that looks reasonable in a budget meeting. Address chronic noncompliance, issue notices, generate revenue through fines, encourage proper waste management. The logic was clean on paper. In practice, what it produced was a series of automated fine notices generated by route inspectors who drove past properties, noted uncollected bins, photographed the absence, and flagged the address in a database. Walter received his first notice in September. He read it carefully. He set it aside, intending to respond. His back flared up that week. He didn't respond. He received a second notice in October with an escalated penalty attached. He called the number on the notice and was transferred 3 times before reaching a voicemail that no one returned. By the time the final notice arrived in December, the one with the cumulative total of $9,200, which included the base fines plus escalation fees, plus a late response penalty that had been added automatically by the system. Walter sat down at his kitchen table and read it twice, and then put it face down on the table and sat very still for a long time. $9,200. He made $14.20 an hour. He worked, on good weeks, 32 hours. His rent was $840 a month. His prescription was $112 a month. He had $430 in his checking account and a savings account that held just under $2,000, money he had been setting aside slowly for the past 3 years for reasons he didn't talk about much, but which had to do with the fact that he was 71 and knew that at some point his body would stop allowing him to work the way he always had. The fine was more than 4 times what he had saved, more than 5 months of his take-home pay. He did not have a lawyer. He had never needed one. He filed the mandatory response form himself, checking the box that said he was requesting a hearing, and mailed it in a white envelope with a first-class stamp. And then he waited. The hearing was assigned to Judge Miriam Okafor's courtroom. Judge Okafor had been a municipal court judge for 14 years. Before that, she had practiced family law, and before that, she had grown up in a household where her father worked 2 jobs and her mother cleaned offices on the weekend, and nobody talked about that directly, but it was in her somewhere. The particular understanding that comes from watching people work very hard and still struggle to stay level. She was not a soft judge. Leniency was not her reputation. Precision was. She was known for reading files completely before hearings, which sounds like a minimum standard, but in a court system that processes hundreds of cases a week is, in practice, a distinguishing quality. She had read Walter Doss's file the night before the hearing. All of it. Not just the fine notices, not just the compliance database flags. The whole file, which, because Walter had submitted a response form, included a brief written statement he had included with his paperwork. 4 sentences, handwritten. He had explained his back injury, mentioned the accessibility line, and said he was sorry for the inconvenience. He had not asked for anything specifically. He had simply explained. Judge Okafor read those 4 sentences 3 times. The hearing was scheduled for 10:15 on a Thursday morning. Walter arrived early. He was wearing his good clothes, a dark jacket, pressed trousers, shoes that had been polished recently. He had brought the stack of papers he had accumulated, the fine notices, his prescription receipt, a printout of his call log showing the dates he had tried to reach the compliance office, the letter from his doctor regarding his back condition. He had organized them in a manila folder with a binder clip. He sat in the gallery and held the folder in both hands and watched the room fill with other people who had other problems. He did not know what to expect. He had never been in a courtroom before. He had never been fined before. He was a man who had spent his life staying out of trouble, working, keeping his head down. The idea that he was sitting in a courthouse because he hadn't been able to carry his trash bins felt, to him, deeply disorienting, as if the world had shifted slightly and he had ended up in the wrong version of it. The case before his ran long. He waited. He sat with his folder. When his name was called, he walked to the front of the room and stood at the respondent's position and identified himself quietly when asked. The city's compliance representative, a younger man in a gray suit who handled these hearings regularly, had the case file on a tablet and began presenting the violation record. 11 weeks of non-compliance, documented photographically, proper notices issued, no timely response received. It was clean. It was procedurally correct. It was also, as Judge Okafor well knew, the partial version of the story. She let the representative finish. Then she looked at Walter. "Mr. Doss," she said, "I've reviewed your file, including the written statement you submitted with your response form. I have a few questions for you before we proceed." Walter nodded. His hands, folded on the table, were very still. She asked about the back injury first. He answered carefully, without exaggeration. He described when it had started, what his doctor had said, what he could and couldn't manage physically on the mornings in question. She asked whether he had documentation. He opened his folder and produced the doctor's letter and handed it to the bailiff, who passed it to the bench. She asked about the accessibility assistance line. He described the calls, the holds, the disconnections, the voicemail that was never returned. She asked if he had those dates. He produced his printed call log. 3 calls, 3 dates, all within the period of the violations. She looked at the call log. She looked at the compliance representative. She asked him whether the accessibility assistance line had a documented response record for Walter Doss's calls. The representative checked his tablet. He looked up. "I'd need to verify that with the department," he said. "I'd like you to verify it now," she said. "You have a phone." There was a pause. The representative stepped to the side and made a call. The courtroom waited. Walter sat with his hands folded. A few minutes passed. The representative returned to the table. "There's no documented response to those contacts," he said. "It appears the calls were received, but not actioned." Judge Okafor said nothing for a moment. Then she asked the compliance representative one more question. "When the automated fine escalation system flags a property for ongoing violations," she said, "is there a step in that process where someone reviews the property record to determine whether the owner has a documented physical limitation or has attempted to contact the accessibility program?" The representative looked at his tablet. He looked up again. "Not currently, no." "So the system escalated the fine from initial notice to over $9,000, she said, without any human review of whether the person being fined had contacted the city for help and received no response. It was not quite a question. She said it the way you say something that you already know the answer to, clearly, for the record. "That's correct," the representative said. The gallery had gotten very quiet. These hearings were usually brisk, 10 minutes, sometimes less. They moved fast. People came in, heard the ruling, left. But this one had stopped feeling routine several minutes ago, and the people waiting their turn in the gallery could feel it. Walter was looking at the judge. His expression was difficult to read. He had spent a lifetime learning not to show too much in rooms where he was not sure of the outcome. But there was something in his eyes, a careful, restrained attention, the look of a man who is listening as hard as he can. Judge Okafor looked at Walter's financial statement. He had submitted one with his paperwork, a requirement of the hearing process. It was simple and honest. His income, his expenses, his savings. No debt, which was something. Walter had lived his whole life without debt. Another quiet form of discipline. But no buffer either. Nothing that could absorb a $9,000 blow without destroying the only safety net he had spent 3 years building. She looked at the doctor's letter again. She looked at the call log. Then she looked at Walter directly. "Mr. Doss," she said, "I want to say something to you, and I want you to hear it clearly." He straightened slightly. "You did what you were supposed to do. You encountered a physical limitation. You contacted the city's assistance program. You received no response. The city's automated enforcement system then escalated a fine against you without reviewing any of that. And you showed up today, on your own, without legal representation, with documentation that you organized yourself and submitted properly, to explain a situation that should have been caught and resolved long before it reached this courtroom." She paused. "That failure is not yours. The fine was dismissed in its entirety, not reduced, not negotiated down to a number Walter could theoretically manage over time. Dismissed, every dollar of it." Judge Okafor noted for the record that the city's compliance program had failed to action documented contact from a resident seeking accessibility assistance, that the automated escalation process contained no provision for human review of documented physical limitations, and that the resulting fine had been generated and compounded by a system operating without adequate safeguards. She noted Walter's compliance history, 23 years at the same address, not a single prior violation, and his good faith efforts to resolve the issue through the proper channels. She then made a secondary notation. She formally referred the case record to the city's Administrative Review Board with a recommendation that the Accessibility Assistance Program undergo a procedural audit. She noted that if this case had reached her courtroom, the system that generated it was likely producing similar outcomes for other residents who lacked the documentation, the fortitude, or the good fortune to have their file read carefully by someone paying attention. The compliance representative wrote something on his tablet. He did not look up. Walter thanked the judge. He said it quietly, with the directness of someone who means it and doesn't need to perform meaning. Judge Okafor nodded, the nod of someone who has accepted thanks but doesn't require it. She moved to the next case. Walter gathered his folder. He walked back down the aisle, past the people still waiting with their own problems in their own folders, and out through the courtroom doors. He sat on a bench in the corridor outside the courtroom for a little while, not because he was waiting for anything, just to sit. He had walked into that building carrying $9,200 of debt that did not belong to him. He was walking out without it. He understood that, technically. But the body sometimes needs a few minutes to catch up to what the mind has just been told is true. He thought about the savings account, the one he had been building slowly for 3 years. It was still there, untouched. The money he had put aside a little at a time from $14.20 an hour because he knew that his body would eventually stop cooperating, and he needed to have something, just something, when that happened. It was still there. That was, for Walter Doss, the thing that mattered. Not the vindication, though that mattered too. Not the judge's words, though he would remember them. It was the account, the $2,000, the small, quiet proof that the years of discipline had meant something and had not been taken. The administrative audit that Judge Okafor recommended was completed 4 months later. It found, among other things, that the Accessibility Assistance Line had a callback backlog of over 200 unactioned contacts going back 18 months. It found that the automated fine escalation system had no integration with the accessibility program's database, meaning that residents who had contacted the city for help were being fined at the same rate as residents who had simply ignored their obligations. It found 11 other cases where fines had been escalated to amounts exceeding $5,000 against respondents with documented physical limitations and evidence of attempted contact. Those 11 cases were reviewed. 8 of the fines were dismissed or significantly reduced. None of that would have happened if Walter Doss had not mailed a white envelope with a first-class stamp containing a response form and 4 handwritten sentences explaining his situation. None of it would have happened if Judge Okafor had not read the file the night before. Both of those things matter. There is a temptation, when we talk about broken systems, to focus only on the brokenness, to catalog the failures, name the dysfunction, express the appropriate outrage, and leave it there. And the outrage is legitimate. A 71-year-old janitor with a back injury who called for help and received none, being pursued for $9,000 by a process that never once involved a human being actually reading his situation. That is worth being angry about. But there is something else here. Something that lives alongside the outrage and is, in its own way, equally important. Walter Doss did not stop. He was a man with limited education, no legal training, no connections, no one advocating for him. He had every reason to assume the system would not hear him. People in his position often do assume that, and often they are right. They pay the fine. They drain the savings account. They absorb the loss and keep going because they do not believe that going to a courtroom and arguing will produce a different outcome. Walter believed it might. Or perhaps he didn't fully believe it, but he went anyway. He organized his folder. He found his call log. He pressed his trousers and polished his shoes and sat in a gallery waiting his turn to explain himself to a room that had no particular obligation to listen. That is not a small thing. That is a particular kind of courage that does not get talked about enough. The courage of the ordinary, the persistence of the person who has no leverage except the truth and decides to show up with it anyway. And Judge Okafor read the file. That also bears repeating. Because the solution here was not complicated. It did not require a new law or a major policy overhaul or years of litigation. It required one person in a position of authority to look at the complete picture rather than the summary, to ask the follow-up questions, to notice the 4 handwritten sentences, and consider what they meant. It required someone to decide that the person standing in front of them was worth the full version of their attention. In a system that processes hundreds of cases a week, where efficiency is necessary and time is limited, and the incentives all push toward speed rather than depth, that decision is an act of will. It is not automatic. It has to be chosen. Judge Okafor chose it. Not because Walter Doss was special in the way that gets celebrated publicly. He was not famous. He was not influential. He was not a sympathetic figure in any of the ways that generate media coverage. He was a man who cleaned buildings and rode the bus and had a bad back and owed the city $9,000 he didn't have. She chose it because that was what the job required. And because she understood, from her own life, from 14 years on the bench, from whatever combination of experience and values lives inside a person and shapes how they see the world, that the function of a court is not to process volume. It is to produce justice. Those are not always the same thing, and the difference between them, on any given day, often comes down to whether someone in a position of authority decides to look carefully at what is in front of them. Walter went back to work 2 weeks after the hearing. His back was having a better stretch. He had spoken with his supervisor about a modified schedule, fewer floors, less lifting, the kind of adjustment that costs a little in wages but saves a great deal in pain. His supervisor, a man he had worked with for 9 of his 23 years there, had agreed without making it a production. He had also, finally, reached someone at the city's Accessibility Assistance Program, a real person this time, a coordinator named Diane, who apologized for the prior unactioned contacts and arranged for a quarterly courtesy check to ensure his bin situation was being managed. It took 12 minutes. It had apparently always been this simple to arrange. Walter didn't say much about that. He noted it. He moved on. His daughter called him the weekend after the hearing. She lived in another city, and they spoke regularly but not constantly, in the way of adult children and parents who love each other and are busy and trust the relationship not to require constant maintenance. He told her about the hearing. She was quiet for a moment. Then she said, "Dad, you should have told me earlier. I would have come." He said he knew. He said he'd figured he could handle it. She said she knew he could handle it. She said that wasn't the point. He thought about that later. She was right, of course. It wasn't the point. But there was something in him, the same thing that had made him organize the folder, press the trousers, mail the envelope, that had needed to see it through himself, not because he was proud in the brittle way, because when you've spent 50 years solving your own problems in small rooms without anyone watching, that's simply how you're built. His savings account still had the $2,000 in it. He did not withdraw it to celebrate. He added $40 to it the following week, the way he always did. There is a version of this story that doesn't go the way it went. In that version, the file doesn't get read carefully. The judge has 7 cases before Walters and is running behind schedule. The compliance representative presents the violation record and the timeline and the proper notices, and it is all correct, all documented, all procedurally sound. And Walter stands there with his folder and his 4 handwritten sentences and is told he owes $9,200, and perhaps it can be paid in installments, and perhaps there is an appeal process, and he walks out of that courtroom carrying a weight that does not belong to him, and goes home and sits at his kitchen table and faces the math. That version happens. It happens regularly, in courtrooms that process volume, in systems that mistake speed for function, to people who have less than they should and are asked to give up more. It happened in this case right up until the moment that it didn't. One judge. Reading a file. Not a revolution. Not a landmark ruling. Not a systemic overhaul. Though what came after, the audit, the 11 other cases, the program review, was closer to that. Just a person in a position of authority doing what the position requires, in the fullest possible sense of that word, and a man with a bad back and a folder and 4 handwritten sentences who showed up. Those two things met in Courtroom 7 on a Thursday morning in March, and the outcome was what it should have been, which sounds like a low bar, which is, perhaps, a low bar. And yet, we do not always get what we should, not in courtrooms, not in systems, not in life. The people who have the least are often the ones the mechanisms are least designed to see. They fall through gaps that were not built to catch them. They are processed rather than considered. They receive notices and escalation fees and automated penalties generated by databases that do not know they exist as anything other than an address on a route. And sometimes, not always, but sometimes, someone decides to look. That's the story. Not of Walter Doss as a symbol, not of Judge Okafor as a hero, but of 2 people, each of whom did what was right in the way available to them. One with a folder and a stamp, and the quiet, stubborn decision to show up. One with a file, and the time it took to read it. Between those 2 things, justice found its way through. It does that, occasionally. It is slower than it should be, and narrower than it should be, and dependent on too many variables that should not be variables. But it finds its way through. And when it does, when it actually does, it is worth paying attention to, not just for the outcome, but for what it tells us about how the outcome became possible. Someone looked carefully. Someone showed up. That's all it took. And that, when you sit with it long enough, is both the most ordinary thing in the world and one of the most important.